Hello, everybody, and welcome to our first lesson in the study of contract law. In this lesson, what we're going to do is take an introduction to the subject of contract law, looking at the importance of it within the general legal system of England and Wales. And then we're also going to outline the structure and the scope for this series in more detail. This is the first lesson in terms of our subject and our study of contract law. We'll take an advanced analysis of the study of contract law in this series of lessons. It's going to be a lot of lessons. We're going to be taking a long time to really get into a lot of detail. And in this lesson specifically, however, we're going to introduce some basic themes and ideas. So essentially defining a contract, looking at the importance of the contract within everyday life, and then talking about the fundamental characteristics of the contract before going on to having a look at the scope of this series of lessons. So ultimately, the question that needs to be asked here is the question of what actually is a contract. Now, one of the things that's quite interesting is, despite the fact that you might not know what a contract is at the moment, contracts are potentially where individuals within society have the greatest interaction with law. So, for example, contracts are made, tens of thousands of contracts are made every single day for all kinds of purposes. So some of these purposes might include very small things, such as the purchase of an item from a shop. They could also include very large things, like the signing of a lease on a property, something that would actually commit you to a significant sum of financial liability, as well as a significant period of time managing and owning, or at least being the leasehold owner of a particular property. So ultimately, the conclusion to this point is that essentially there are tens of thousands of contracts which are formed on a day-to-day basis. And for the most part, there are very few problems with these contracts. Of the tens of thousands of contracts which are formed every single day, some of them being very implicitly established, like, for example, purchasing an item from a shop, some of them being far more formal and substantive, like the signing on a lease on a property. Most of them have very little in terms of controversy. But there will be a very small number of these contracts which are challenged or put under scrutiny in a court of law. And this is really where we get our idea of what contract law is essentially getting to the heart of. These difficult issues and these difficult questions relating to the nature of a contract, the enforcement of a contract, bringing a contract to an end, what actually is a contract, all of these different kinds of questions. So, simply put, the most simple way in which we can define what a contract is that a contract is simply just a legally enforceable agreement. This does not tell the whole story, because not all agreements are classed as contractual, because this idea of what is legally enforceable in terms of an agreement is essentially doing quite a lot of heavy lifting in this definition. There are certain formalities and requirements for what essentially creates a contract, one that is actually an actual contract, which is a legally enforceable agreement. So not just all agreements at all can be classed as a contract. So a person that I have an agreement with, if they were to fail with their obligations, that does not automatically mean that I can sue them for breach of contract. The question of whether or not a contract is present requires more than just this simple definition that is stated here. Given the fact that contracts require a number of different elements to be considered binding, we have to then think about, well, what are these different elements which are to be considered binding? So, even though we're going to spend a lot of time examining this in far more detail in future lessons, I will give you right now the essential elements of a contract as defined and as established by just essentially the history of contract law. So the first part of a contract is that in order for a contract to exist, there has to be an agreement. Now, the agreement factor, the part of the contract which is considered to be an agreement, is made up of two distinct elements. You have to have an offer in conjunction with an acceptance of that offer. And in this series of lessons, what we're going to do is, despite the fact that essentially you can't have an agreement without both of these factors. You should we're going to essentially delineate each of these topics separately. So we're going to talk firstly about the concept of an offer. What is an offer? What is the distinction between an offer and, for example, an invitation to treat? What kinds of circumstances do we find an offer? And then we will also talk about what is an acceptance of an offer, what constitutes the acceptance of an offer, how ought acceptance be conveyed to the person who is making said offer. The second part of a contract that is required is this idea known as consideration. Now, consideration essentially just means something for something else. So there has to be some kind of exchange of some kind of value. So if I were to purchase an item from a shop, the reason why that is a contract is because there is consideration. There is the fact that the shop owner is going to get some of my money in return for me getting the item that I want. This is the sort of quid pro quo that exists within all kinds of contractual arrangements. That's what we'll look at in a future set of lessons. We'll talk about what actually it means to have good consideration of in relation to a contract for a contract to exist. There also has to be a combination of certainty and an intention to create legal relations. Remember, from our previous definition, a contract is a legally enforceable agreement. So there has to also be the intention to create legal relations. There has to be this belief that the parties who are entering into this agreement with this consideration, with this offer and the acceptance of the offer, that all of these things together are done under the auspices of this intention to create legal relations. Now, those are the three main requirements or elements of a contract, but there are also other requirements depending on the type of contract which you are signing. So there may also be formality requirements for certain contracts to be valid. So, for example, in certain circumstances, it might be a requirement that a contract be done in writing rather than an oral contract, which is just done via spoken mouth. Now, while this is a necessary requirement for some contracts, it is not a necessary requirement for all contracts. So we would not suggest that the idea of it being in writing or formally enshrined in writing as a condition for contracts as a whole, a necessary condition for contracts as a whole. It might just be a necessary condition for specific contracts of specific types. But we will get to that, and we will get to looking at the distinction that is made between oral contracts, verbal agreements, as well as written-based contracts too. So, given that, let's look at the scope of this series of lessons. What are we actually going to cover, and in what order are we going to cover it? We're going to begin, as you might expect, by talking about the creation of a contract, talking about all of these elements that we see here and what they actually mean, what they actually require, and how people have interpreted them over the years. So we will talk about the nature of an agreement, we will talk about the idea of the offer versus the acceptance, and then we will talk about the subsidiary factors. Subsidiary not implying that they are less important, but just implying that they are not part of the enshrined part of an agreement, for example. So we're going to talk about certainty, intention to create legal relations, and consideration. We'll then also finish this little first topic on the idea of promissory estoppel. The second major topic is going to talk not about where contracts come from, what contracts are and how they are formed, but more the contents of a contract. We will talk about the terms of a contract, talk about the idea of terms and versus representations, talk about this idea of warranties in certain consumer-based contractual arrangements, exclusion clauses and unfair terms. The third section will talk about bringing a contract to an end. The various circumstances whereby a contract may come to an end, including by way of misrepresentation, duress, undue influence, as well as the doctrine of frustration and mistake. In relation to this as well, we will cover very, very briefly the idea of performance, which is, of course, the most common way in which a contract comes to an end. Performance is really where all the parties make a contract, they agree to a contract exists, and then they just perform the terms of their contract. They perform their obligations under the contract, and then once they're done, the contract ends. Of course, that is the most important, or at least the most common way in which a contract would come to an end. Of course, that's not particularly very interesting for lawyers, because we're talking about all of the more messy situations where contracts come to an end, like frustration, mistake, undue influence, and duress. And then finally, we're going to talk about the various different remedies and damages for potential breaches of contract. So we'll talk about what it means to breach a contract, the idea of compensatory damages, liquidation of damages or liquidated damages, limitation of damages, and other remedies which may be available in both law and potential equitable remedies that could exist in relation to contracts being breached.